Okay, hi, good morning, English learners, the participants, the zealous participants who are always waiting for the wonderful session that's called Hindu Editorial. So we are back with this brainstorming session that's called Hindu Editorial. So today's session is all about I can say just scroll down. Let's have a thought of day. The thought of day today is that you are braver than you believe, and stronger than you seem, and smarter than you think. It's all about just underestimating yourself, and just you should wake up and just believe in yourself, and you are more what you think about yourself. So you do have ability, potentiality, and once you believe in yourself, I think world is yours. You can just crack the puzzle, you can fulfill your dream. So that's all about thought of today. Let's move directly to the our editorial page. Before starting, actually, I should give a crux of the of today's Hindu editorial page. It's all about the Gujarat riots in 2002, and there had been a lot of massacre and lots of crimes had been committed. Some women had been raped, etc. So there are some criminals, actually convicts, who had been convicted by the court. They are lingering in the jail, and the government somehow had come up with a proposal to give them a set period, I can say, to release them from court. And civil society is not satisfied with that. Okay, civil society is saying that these criminals had committed some heinous crimes because the punishment given by the court is already for death sentence. I mean to say lifelong imprisonment. Okay, imprisonment. But government had come up with the order. They are remitting their sentence. So it is an issue. The order of the government, it has come up with a backlash. Okay, backlash means criticism from the society. So this is actually the editorial page. It is what about our editorial pages today. So here the term is reviewing remission. What actually remission means? It's a legal term. Okay, a remission, or there is suspension and commutation. A remission means if it means to decrease the amount of punishment. Okay, but maintaining the same character of the punishment. I will give you an example. For example, if the punishment, for example, is for 1 year, if the court, while hearing to the argument, and court had finally decided that criminal should be awarded 1 year punishment, but in the middle, government is, or court is coming up, court is remitting his punishment, court is just reducing the punishment up to 6 months only. This is called a remission. Remission means to lower down, to less down the punishment. Okay, the amount of punishment, that's called a remission. The second term, related term, is suspension. Suspension means to postpone. For example, if someone had committed crime, court is providing him death penalty, but now court had issued again one order. They are suspending this death penalty. They are putting him in the jail. Just wait for some time. Let's see what will happen. So that means they are suspending. That's called suspending. Okay, that's called a suspension of punishment. Okay, suspending punishment. The third thing is commuting punishment. Commuting sentence means if court had awarded death penalty, after some time court is changing this death penalty into life imprisonment. So these are three terms, okay, mostly used in legal language. One is called remission, the second is called suspension, third is called commutation. Okay, so here actually we are related with the term remission. Remission means to lower down the punishment. Maintaining the character of punishment is put same. Okay, for example, again I will quote you an example. 1 year is the punishment. Court is saying now only do it only 6 months, because the character of person is still good, because his record is being checked. Okay, so court somehow, so in this case, actually about our case Gujarat, right, some people had been accused for some crime. So they had been already awarded with the life imprisonment. Okay, life imprisonment. But this time court had recently, government had recently come with the proposal. They are releasing them, but this order had faced backlash. Let's move. So reviewing remission. I hope you got the word remission. On the need for norms to release convicts, convicts, Supreme Court should lay down norms for release of convicts. I already told you what actually norm remission means, but here the author is saying that Supreme Court should come up with the clear idea that what kind of criminals are justified for remission, what kind of criminals deserve remission, and what kind of criminals don't deserve remission, because it is just a little bit, we can say, forgiving. It is just when government is coming up with a relaxation. Okay, so here the author is trying to say court should come clear, it should categorize between the crimes, that what kind of criminals should deserve remission, what kind of not. Okay, because here actually the thing is that the nature of crimes committed by these criminals is of it's of heinous nature. Okay, so maybe author is trying that they should not deserve remission. Okay, convict here is the word convict, and being charged. Convict is when court officially announce something as criminal, that time you have to use the word convict. Okay, for example, we used to say he was convicted for theft, he was convicted for theft, he was convicted for kidnapping. Convicted means once court issues order, once court comes up with an order and is publicly declaring someone as a criminal, at that time he is called convict. Okay, otherwise there are always charge, we used to say offender, etc. We may give different words, but once court gives a punishment, once court comes up with a straightforward order that some declaring someone offender, that's called convict. Okay,
So, can
or
I correct you for a second, Silent Boy? Just for a
yes.
second. Yes. So, whenever court delivers a judgment, at that time, the person has been convicted. Before that, he is an under trial. Orders are always given in civil proceedings. Thank you.
Yeah. Thank you, sir. Thank you. Yeah, judgment and order. Yeah. I understand. Thank you, sir. So it's all about. I was just talking about conviction. So conviction is when officially judgment is announced. That's called conviction. Okay, let's move ahead. Uh, Scroll up a little bit. I lost an idea. Little bit. And we scroll up. ऊपर जा थोड़ा सा. Yes. For the release of convicts for on remission. Okay, go down now. Yes, now the here is, yeah, public spirited activists have done well to challenge the supreme to challenge has done well to challenge in the Supreme Court the premature release of 11 convicts. Public spirited activists means actually here civil society. Okay, it may be the well-thinking people of the society, well-thinking or intellectuals of the society. Public spirited activists have done well. Means it's appreciating the author is appreciating them to challenge the Supreme Court the premature release of 11 convicts. Premature here means before the due date. Okay, there were the sentence was actually for that this was life imprisonment, but this time government has tried to release them before. So civil society is coming forth. They are just challenging this order they are gonna to challenge this order in the Supreme Court. It is as simple. 11 convicts who were serving life term for gang rape of a woman and murder of at least 7 people during 2002 anti-Muslim program in Gujarat. So it's all about, I think. So here actually the offenses committed by these criminals, it's being actually highlighted that they had gang raped, they had been involved in gang raping, the crime of gang raping, and had also been involved in the heinous offenses like murder. So these are 11, I can say, 11 offenders who had been declared as who are serving in the I can say jail for the punishment of committing crime against women as well as murdering, had done murder of many people. Okay, so this is actually the heinous nature of crime. That's why civil society had come into fore. They are trying to just go. They are trying. They are actually moving to Supreme Court for against this order of I can say this remission order. Okay, okay, move down, scroll down. SC refers 7 judgment bench issue. Okay, Bilkis Bano, the survivor, has not moved the court so far. Bilkis Bano, the survivor. Survivor is actually, it's a person who remain alive in an event of others' death. Okay, so someone, if there is any event and many people have died, many people have actually passed away, the person who just remains alive, that's called the survivor. Okay, it's mostly related to siblings. If many people in the family have died, the person who remains alive, that's called survivor. Okay, the survivor, for example, I will give you an example here. The survivor family of the survival family of the deceased were given 50 lakh rupees and one government job. It means survivor who's actually who's sustaining, actually who sustains life, who gets out of that actually event, the dreadful event, who actually sustains life. Okay, so Bilkis Bano is the woman, actually the survivor, has not moved the court so far, but it's clear that the controversial order of the Gujarat government granting remission to the convicts should be subject to the judicial review. Okay, here is actually the I can say the crux, actually the essence of this whole this paragraph, or I can say the editorial page. The controversial order actually is issued by the government. So under it is actually a legal procedure, actually, where government gets Supreme Court had already actually given the jurisdiction, I can say right, to the government to decide whether the person considered that the culprits, you can say the convicts, they deserve remission or not. It is actually under section I can say 432, I think, from CRPC. It's a situation where Supreme Court gives some authority to the government that they can see, they can look into the issue after taking into consideration the previous record of the criminals, whether they deserve remission or not. Here the thing is that the controversial order, actually order is issued by the Gujarat government, because under Constitution of India, the court can give authority to the government that they can just give the remission to any criminal. Okay, so government have to apply the judicious mind at that time. They have to apply the sense that whether they have to take into actually consideration the previous record, the character of the criminal. Okay, so once the government issued this order and they released the criminals, but it became a controversial order in the eyes of people. Okay, in the eyes of public. Okay, granting a remission to the convicted should be subject to the judicial review. Judicial review, it's also a legal term. Judicial review actually means when government takes some initiation, government passes some law, government issues some order. If this law, it violates any tenet of constitution, it becomes the subject of judicial review. Judicial review means court can review this this order, or this I can say this law. That's called actually judicial review. So at the same time, here we can say that government had actually issued order, it is releasing some criminals. Okay, but court at the same time, according to author, author says that this order should be judicially reviewed. It should be judicially looked into again, whether it is a fair order or it is violating the rights of those I can say innocent people who are actually victim of the 2002 rights. Granting remission to the convicted should be subjected to judicial review. That those found guilty of multiple murders, including that of 3 years old child, and gang raping. Gang raping means actually when 2 or more men are raping a single girl. That's called gang raping. Means they have actually committed a heinous crime, the crimes which are of serious nature. Okay. Again, where found suitable candidates for premature release is unacceptable. Means the author is actually saying that it's unacceptable. The criminals who had committed serious crimes of serious nature, still they are enjoying the premature release from the jail, okay, from the lockup, okay. Even otherwise, there are specific legal grounds to question the government's decision, because the decision actually hereby the decision actually had been taken by the government. The author is trying to say that there are multiple legal grounds to challenge this order of the government, where they are releasing some criminals who have done the crime of heinous nature, but government is coming up with the order which sounds arbitrary, or you can say there is no application of judicial mind. So there are actually, the author is trying to say that there are actually lots of, there are, this order is actually erroneous nature. It's of erroneous nature. It is lacking the spirit of law. It's violating itself a law. That's why the author here is trying, there are legal grounds. Legal grounds means there are constitutional, I can say constitutional, there are constitutional ways that whereby this particular order can be challenged. Okay, so let's scroll on. Scroll on. The remission was based on direction from two-judge bench of the Supreme Court on a petition by the convicts. Okay, actually, the convicts means the people, the person who had already been charged of crime, and they are now in jail. Actually, they had earlier moved an application. Plea means actually application in court terms. In court terms, it's application. Actually, when you are moving an application in front of court, actually to the court, actually that's called plea that time. Okay, so the actually one of the criminal, or one of the convicted person had actually moved an application earlier. They had sought remission before the Supreme Court, and Supreme Court at that time has referred this case to the government concerned. I can say state government. I already told you it is a legal procedure that for remission affairs, the Supreme Court mostly they try to refer this case to the government concerned, so that government is actually the best authority there. They can check out the records, they can check out the previous character, okay, the earlier, what kind of person he is, etc. They try to know more details. So Supreme Court don't have so much time. They cannot just check more details. So government at that time, actually state government is taken into consideration. The case is strictly referred to the state government. So the author here is trying to say that actually criminal earlier had tried to approach to the Supreme Court just seeking for remission of the sentence. Okay, so but Supreme Court at that time, the judge in the Supreme Court had referred this case to the government, and what government actually did, they provided remission. Okay, but unfortunately it led to the public backlash, public criticism. Okay, the remission was based on direction from the two-judge bench of the Supreme Court on the petition means also plea application, okay, by one of the convicts. The question to be decided was whether the Gujarat government or Maharashtra government was the appropriate government for considering their plea for remission. So here it is actually it's matter to it's a considerable matter. Actually, it's called actually the convict, maybe the convict was from Maharashtra. He had committed crime in Gujarat. Okay, because the place of commission of crime is Gujarat. Okay, by how Maharashtra is coming into fore here, because the author is using here, he's also identifying one more state is Maharashtra, means the criminal is actually from Maharashtra, because it's called a jurisdiction of a particular court or government. It's always I will try to understand this way. Where the offense is committed, either you can sue, or you can just sue someone there, or the place of suing can be the state where found the offender is. Maybe the jurisdiction, it's all about actually the jurisdiction of court. Sometimes court do have extra jurisdiction, means it can just go, if the criminal is from other state, either he can be sued there, if if the either a criminal can be sued in a place where do he reside, or he can also be sued in a place where he had committed crime. Means if the criminal is from Maharashtra and he has committed crime in Gujarat, he can be sued in both Maharashtra or Gujarat, because he belongs to Maharashtra and he has committed crime in Gujarat. Both the courts from Gujarat as well as Maharashtra both have a jurisdiction to try this person for some offense. So here, but here the question is that the criminal is already in your hand, criminal is already there, he's in jail, so the appropriate place to sue him will be Gujarat. Okay, so here but unfortunately the Maharashtra government has tried to to take procedure, I can say go with the procedure. Okay, but here the legal question here is that the question is to be decided was whether the Gujarat government or the Maharashtra government was the appropriate government for considering their plea. So it's all about plea, about remission. But Supreme Court is of the opinion that Gujarat government was the appropriate government to consider their plea of remission, not Maharashtra. Maybe he belongs from that, but he belongs to Maharashtra, but he had actually committed the crime in Gujarat. So Gujarat government is the best authority, I can say, is the appropriate authority to try him. Okay, so let's scroll down. Kindly scroll down. Leo, scroll down. Leo, scroll down. No. Hello, Leo. So it is matter of all jurisdiction, and I don't know. Leo is probably not here. Let me to handle it until Leo. Okay, he's now here. So while passing this order, the bench also said the remission should be considered under a policy framed in July 1992, as that was the prevailing policy on the date of their conviction. So there is actually remission. There is remission policy 1992. Remission 92 policy was actually that when someone is punished with the sentence of life imprisonment, in the middle government used to take the government used to take a that kind approach. They used to adopt kind of approach. They used to give him remission, provide him the remission, but only after when due to rape cases had actually increased in India. So the new law, actually law had actually a little bit changed, that 1992 those rules, those I can say remission laws has been actually amended. So due to the increasing crime rate in India mostly against women. So before that, actually in 1992, the situation was different. The people who had come up with a crime, who had committed a crime, they were provided remission. Okay, remission was also an opportunity for a criminal to mend his ways, to improve his, I can say, character. To provide him some more training so that he can resume back his social activities. He can be a good citizen. So, but actually, this offense, actually, this I can say these rights actually happened in 2002. At that time, these 1992 I can say remission laws were prevailing. Okay, these were more these were operative. Okay, so the thing is that the author is trying to say these criminals are they are actually dealt according to they are guided by, they are dealt according to the, I can say, remission policy of 1992. But we have to see that remission actually 1992 policy for remission was liberally drafted. This policy did not put strict restrictions on remission. Most of the criminals with recorded good behavior, having completed a considerable number of in jail were remitted under the said policy. So they were actually remitted. They were remission was a possibility there that time. But at the same time, the roots of this actually this case about which we are discussing actually 2002 riots happened in Gujarat. So its roots goes back 2002. So at that time, actually those remission policies of 1992 they were actually in action. So they are legally they are they are guided by that policy. So the new policy cannot be implemented on them, okay, because new policy is quite strict. On that basis actually remission was actually granted to them because they deserve. They had they had spent a quite considerable time in jail, so they deserve remission under the rules 1992, as that was prevailing policy on the date of their 2002 conviction. This meant that the bar on granting remission to those convicted for murder and rape found in the current policy will not apply to these convicted. Same, it is saying that 1992 policy is applicable to these criminals, not the updated policy. Updated policy is quite strict. The updated policy of the regarding these remission cases, it's quite strict because the graph of offenses against mostly against women is actually increasing. There is kidnapping, there is abduction, there is robbery, there is lots of crimes. Okay, there is cruelty. It has become actually order of day in India that the crime rate is actually increasing. So that relaxed policy which was 92, it is not now applicable. But for these criminals, actually they have committed crime back in 2020 2002. So at the time that policy was that relaxed policy was applicable. So that's what I'm trying to say, that policy is actually legally even that is actually applicable to them. So let's scroll down. So there are at least two grounds on which the remission order appears illegal. First, the government made a decision on its own without consulting with the sender. So here the question is that why this remission actually has become objectionable now again in Supreme Court, because it has been already been objected. It has been again already being outruled in Supreme Court. Why? The reason is that before this government has taken steps for remission policy, has adopted remission policy, had provided remission to these criminals. They were supposed to take into confidence the center, because what is actually the reason? CBI was involved. CBI is actually Central Investigation Agency. So CBI was actually involved in investigating these offenses. So once CBI was involved, means central government has a part into it. So before this state government was going for some remission policy or providing remission to these culprits, these offenders, they were supposed at least to convey to the central government. So that had become one of the reasons to challenge it in a fresh way in Supreme Court. Okay. So what is the second reason? Actually, first, the state government made a decision on its own without consulting with the center. So I had already, explained it. Let's scroll down. Please scroll down. The presence of political members certainly vitiates its decision. Further, it appears that the objection of the district judge concerned was disregarded, casting a shadow on the legitimacy of remission. So legitimacy of remission was again challenged on the ground that even the district judge's consultation, his recommendation was not taken into consideration by the state government. Means the court recommendation, court, or the court is sometimes giving you a direction, the government is supposed to abide it and go accordingly, because the judge knows law. So government cannot, government is not in a position to know the law, because it has many technical terms, many technicalities are involved, mostly if it is regarding some criminal cases. So government is not the best authority to decide. Okay, so at that time even the district court has provided some recommendations, some advisories that even the government has not listened to that. Okay, So the presence of political members at the same time, there had been in this the panel who had decided to provide remission. Some BJP members had been there. Some BJP politicians had been the part of this this remission that team. I can say the team which was formed. BJP members were there. Court recommendation had not been taken into consideration, and you can obviously I can say it is prima facie you can understand that that there it's challengeable. It's because a political party, a member who had some political faith cannot be member of any committee which is deciding the future of any criminal. I can say deciding any fate of any criminal rather. So okay, so the presence of the political member certainly vitiates the decision. Or further, it appears that the objections of district judge concerned was disregarded, as I was saying, casting a shadow on the legitimacy of remission. Means the legitimacy of that remission itself became objectionable. It will be appropriate if the Supreme Court constitutes a bench of remission policy obtaining on the date of conviction. So it is advisory if Supreme Court will come, as the author had in the beginning said, just come up with some norms. Okay, so again here author is saying that it will be quite good if Supreme Court will come up with some remission policy and just make it clear. Actually it's confusing, so it's confusing. So that is why here we find in Gujarat some politicians are even figured in the committee which is deciding the fate of criminals who are seeking remission, because it's a legal issue. A politician cannot know law. Even he don't he have a certain belief. He is already have a belief, such belief which is not impartial, which is not neutral. Okay. The bench of a sufficient size to reconsider the judgments that allow the remission policy obtaining on the date of conviction instead of policy currently in force, as well as decide the question of whether the appropriate government should be one of the state where the crime took place or the state in which the trial was transferred on judicial orders. It's all about what I was saying you, this issue of Maharashtra and Gujarat, where it should be tried by which state has a proper jurisdiction, appropriate jurisdiction. But according to the Supreme Court, according to the Supreme Court, have even made it clear in this in these details that Gujarat is the appropriate government, or even the court of the Gujarat can just try it, not Maharashtra, because offender is already there. If he would have been if he would have been not found, if he would have been declared as a proclaimed offender, then the situation was different, then the condition was different. But offender is already there, and it is the Gujarat is the appropriate state, or the Gujarat High Court is the appropriate forum to try this case. Okay, let's scroll down. Three judge or five judge bench. So these are actually judges trying to highlight, sometimes called full bench, sometimes called a division bench. So these are some of the terms in law. It can also spell the counters operational remission policy. It can also spell out the counters operational remission policy, one that will be informed by humanitarian considerations, as well as the scope for reform of the offenders and their sense of remorse. So actually the author is here trying, if Supreme Court will come up with counters with clear policy of remission, it has many benefits. The first thing is that it will be the policy will be actually based on some humanitarian basis. Okay, because it will also take into consideration that a person who had been lingering in the jail for a quite long time, he needs some can say some gap to be back in the society. So because here the word is humanitarian means in that sense. Okay, at the same time the policy will be clear. If then the Supreme Court is just handing over the case with remission case to the government, then at the same time government will be clear, it will be fully guided that what way, how it can actually come up with the remission with the policy of remission. It will just implement it according to the law. Otherwise there is chaos, there is confusion, there is unclarity. Okay, so the author is trying to say that. Okay, let's go, please scroll down. Reviewing remission, the Hindu editorial on need of norms to release convicts. He is one of the convict. Yeah. Reviewing remuneration convicts in the Bilko Bano case. It is actually Bilki's Bano case. Actually, she had not moved to the court as she is the survivor of the event. I can say suicidal event. You can say very bad event. Actually, she has lost her family members. They were murdered, and it's actually mentioned in the editorial page. So, tune of the editorial. So, what is the tune of editorial? So, anyone, I think what it is for me, it is critical because even Supreme Court has been here critically evaluated that it has not Supreme Court had not yet come with the clear policy on remission. Okay, remission policy is not there. Okay, so I think it's somehow there. It sounds to be critical, but other parts I can see it's more informative. So I will leave upon you participants, learn participants, that what do you think? What is actually the nature of this editorial page? So, anyone, what do you think? What is the tone of this editorial page?
Analytical.
Yes, analytical. That's quite considerable. Yes, it's analytical. Yeah, analytical means that's providing, applying logic, applying mind, and then try to differentiate. Yeah, it's like, there is Maharashtra government, on the other hand Gujarat government, Supreme Court, state government, jail, etc. Many things are involved here, so it's just that kind of comparison even we can see. So anyone or want to add anything? It's because it's quite technical topic, it's of legal nature. Everyone cannot do this topic, it's quite technical. Yeah, anyone, please come up with your suggestions also if you do have, or if what you actually understood, you want to make a summary of it, do commentary on it, you're most welcome.